So we've been talking a lot about how realists think about the ways in which states interact within the international system, right? Focusing on statecraft, focusing on balance of power. But liberal theory argues that international law is really central to the interactions of states and helps to manage those relationships. So it's worth spending some time talking about how international law operates within the international system. So it's first of all important to note that international law doesn't come about the way that law comes about within states. There's pretty clearly defined ways in which states create laws, whereas international law is much more mushy in terms of the process of how it gets created and how it operates. And so one mechanism that states can use to create international laws through international treaties or international conventions. These are written down almost like contracts that states negotiate amongst themselves and work out what are the rules going to be that are going to manage our relationship, right? And so with a treaty, you have two states that are signing on to a set of rules that says this is what we're going to do, how we're going to interact with each other, what are our obligations toward each other. International conventions are aimed at setting out more generally the rules of the international system, and how those rules are going to play out, and what are the expectations for states. And so with international conventions, the contract approach maybe isn't quite as accurate, because with international conventions, if a large number of states in the international system, say 100 or 150, sign on to a convention, there can be the expectation that that becomes the new set of rules for the international system. And even if you haven't signed on to that particular convention, other states might expect that you hold to it anyway, because it becomes the new sort of norm for the system. And that might seem a little bit to run counter to the idea of sovereignty of states, but I'd maybe sort of suggest that it's best understood in thinking about another way of making international law, and that is international custom, right? And so there's a long sort of tradition in international law that if a practice between states becomes so routine and so widespread that states begin to believe that they should be bound by that practice, by that custom, by that way of interacting, then that practice has taken on a new sort of legal quality called opiniono juris, the idea that you believe that you are to follow this as a law. That when states routinize their interactions to such an extent that it essentially becomes a binding international law for the system. And so I think conventions could be thought of maybe a more formal way of establishing when something has become so widespread and so entrenched that it becomes the new law of the international system. International custom over the years has been in decline because we've moved in the direction of codifying a lot of these conventions, conventions that emerge in terms of treatment of diplomats, right? That you don't torture diplomats, that you don't arrest diplomats, that diplomats have immunity from prosecution. All of those were things that emerged as customary international law, that states just realized over time, I shouldn't abuse the diplomats that are sent to me because that will result in all sorts of bad things. And they began to believe that this was just the way the system operated, and therefore it became law-like. Similarly, rules governing, how ships operate at sea, right? The idea that if you come across a shipwreck, you pull people from the water, you don't let them drown, became entrenched as customary practice in international law, and then later got codified in the UN Convention on the Law of the Sea. So we've moved in the direction of codifying a lot of this international customary law, but the principle that widespread practices can become binding upon the entire community is really a core foundation for international law. A second or third way that you can get international law emerging is through what looks somewhat like a legislative process in a democracy, through resolutions that are passed by international representative bodies, right? And so organizations like the United Nations can pass resolutions through the UN General Assembly, and those resolutions are, well, they don't have the force of law like laws passed by Congress. They don't have that at all. In fact, a UN General Assembly resolution isn't binding in any sense of the word. No one is obligated to follow that or even treat it like international law. But if year after year after year, the UN General Assembly is passing resolutions stating what it believes are the principles and expectations of other states, over time that can accumulate into sort of a collective body of resolutions that can demonstrate this is the broader will of the international community for how things should operate, for the rules that we should follow, for the expectations from member states. And that can sort of, in the path of customary law, build up to something that looks like international law, where states are expected to do these certain things, are expected to behave in certain ways, to follow certain principles. And the one exception to this would be the UN Security Council, which has certain powers under the UN Charter to be able to pass resolutions that are actually binding on other states. And we'll talk about that in a second. A final mechanism that goes into crafting international laws is really important, but I think maybe underappreciated, and that is that the decisions that are crafted by judges who hear international legal cases in international tribunals, international courts, as well as the writings of legal scholars, really are helpful in terms of understanding how international law actually operates on the ground, right? And so this is something that, if you're not sort of immersed in the legal tradition, you might not fully appreciate. But laws are written at a pretty abstract level. Figuring out what they mean in practice in everyday situations, and what the ambiguities in laws actually mean and how they should be interpreted, or how conflicting elements of law should be interpreted, is the heavy lifting work of lawyers and judges as they work through case law, as they publish articles in legal journals in which they talk about, well, you know, this law might mean this, or it might have these implications under these circumstances, or this would be a way to apply this law fairly. That's really important for being able to get laws to actually function on the ground. Similarly, when judges rule on cases, those rulings, they lay out the principles that they were relying upon, the way that they viewed the case, the relevant details, how they're interpreting the law, and that becomes a precedent that becomes useful for understanding the interpretation of the law going forward, right? So it's actually a much more robust system than just what's, you know, in the treaty. There's also this whole legal structure around it in terms of how it operates and how it gets implemented. Okay, so we've got international law that's out there, but we still have a sovereign state system, a system in which no one's really in charge of states. No one can make a state do anything. And yet, we have this concept of international law that sort of implies that states are bound and maybe in some respects obligated to follow these sets of rules. And what's even more puzzling is that the vast majority of states accept the vast majority of international law the vast majority of the time. And yet they don't have to. And yet no one's making them do that. And I think it's worth thinking through why we actually follow rules at all. And before we talk about international law, I'll give the example myself. I don't always wear my seatbelt. I'll say that. And if you think about how seatbelts are enforced, maybe that's not so surprising. I've never been ticketed for not wearing a seatbelt. I don't know that in the state I'm at, that's actually a thing that happens on a regular basis. I don't think that law enforcement prioritizes that. So when I do put on my seatbelt, it's not always because I'm fearful that somebody's going to come at me and give me a fine or throw me in jail. When I wear my seatbelt, it's usually because I'm on the interstate. And I think, gosh, if my car crashes, I'm going through the windshield. That would be bad. I don't want that. So I'm going to follow the rule. I also follow the rule when I'm with my family. And they look at me and say, why aren't you wearing your seatbelt? So I put on my seatbelt. I wear my seatbelt when I'm in my van, not in my truck, because my van will ding at me if I don't wear the seatbelt. It says, ding, 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 you haven't put on your seatbelt. And I can drive as many miles as I want. It will continue to ding, believe me. I've tried. That little dinging, as annoying as it is enough to sort of incentivize me to put my seatbelt on. Well, when we think about international law, it actually works in a very similar way. A lot of times states follow international law because international law is just practical. It makes sense. It's like not wanting to go through the windshield of a car. As long as I do this, I'm unlikely to get myself into trouble. I'm going to avoid misunderstandings. Things will work out better. Right? There are all sorts of rules governing aviation and international flights. States follow those rules because they don't want their planes to be shot down. They don't want to have, they don't want to be responsible for shooting down civilian aircraft, passenger planes coming into their territory. And so we all follow the rules and things just work better. And through repeated interaction, states learn, yes, following the rules works really well. I'll do it. Everybody else will do it. Let's just stick with that system. They also follow the rules because they see those rules as legitimate, right? The process by which that rule was generated. I sat down and negotiated this treaty. I was part of the legislative body that discussed this and passed that resolution. There's a sense of legitimacy in international law that I think helps states accept it and argue that, in fact, they should be doing this. And then finally, there are a mix of rewards and incentives and, to some extent, coercion. Some of that's very simple. It's that little ding, ding, ding. It's my wife turning to me and saying, "Why aren't you wearing your seatbelt?" That kind of peer pressure or annoyance of not following international law. But there is also the potential for actual consequences, for actual coercion if you don't follow international law. So I think let's talk through some of the mechanisms that are used for enforcing international law. Okay, so one of those mechanisms is reciprocity. Reciprocity is really important, right? Reciprocity is the idea that I will treat you as you treat me. And when we think about international agreements, a lot of international agreements are actually written in a way that allows for reciprocity, right? And so with international trade agreements, they almost always have the statement that says, we're all going to lower our trade barriers, but if there's one state that's cheating, that's sort of imposing tariffs on another state, then you can respond. You can impose tariffs on them as retaliation. When they lower your tariffs, you take your tariffs off. And that makes the agreement at least relatively, maybe not stable because it can be upended at any particular moment, but at least gives states the confidence that they're not going to be taken advantage of, that they have the opportunity to retaliate, that there's a consequence and a punishment for rule breaking. There's also reporting, right? So many international agreements have a reporting mechanism where states will either self-report, they will give a detailed accounting of what they're doing. And so with the Nuclear Non-Proliferation Treaty, states will file an annual report with the International Atomic Energy Agency and say, hey, this is what I'm doing in terms of using nuclear technology. This is the fissile material we have stored within our country. Here's how it's stored. Here's what we're doing in terms of research and development. And the International Atomic Energy Agency, or actually anybody, can look at those reports and see what states are doing and make a determination of whether or not they're in compliance with the promises they've made under the Nuclear Non-Proliferation Treaty. And the International Atomic Energy Agency will file a statement that goes along with those reports and say, we certify that we believe that this state is in compliance, or we have grave reservations that the state is not in compliance. And you might say, well, is that really a significant way of constraining states? Is it that a report up on the internet says something negative about a country? Is that really a constraint? And it turns out it actually is, because it's like the ding, ding, ding of my car telling me put your seatbelt on. I reach a point where I say, fine, I'll take the small steps, I'll do the thing I need to do to be in compliance, to make the dinging stop, to make the regular flagging of my violation of this particular rule, to make that annoyance go away. And then a final mechanism that we see used is adjudication, right? That if states are in violation of international law, they can be sued under international law. There are court systems designed to do that. Whether or not that's binding or not, it depends. But the idea is that states are going to hand over control of an outcome and let a judge, a neutral third party, look at the situation and provide a solution for how to move forward. Adjudication is a pretty old mechanism. It's been in place for a little over 100 years. There was an International Court of Justice that was established at the end of the 19th century and on into the 20th century. It was incorporated into the League of Nations. When the League of Nations collapsed, the International Court of Justice sort of persisted and was picked up and incorporated into the United Nations. It consists of about 15 judges. They hear a handful of cases every year, only about 2 to 3 cases a year. And they form rulings, and those rulings say this is a dispute about how international law is being applied or interpreted, and here's what we think should be done. And so that builds up that body of understanding of international law. It also flags when a state is in violation. And if states have signed on to the optional statute giving the ICJ compulsory jurisdiction, they're promising that when the ICJ issues a ruling on a case, that they'll abide by that ruling. There are other courts that do this as well. Within the European Union, there's the European Court of Justice, which helps resolve disagreements between European Union member states about whether or not states are living up to their treaty obligations and following the rules laid down by the European Parliament and other organizations within the European Union satisfactorily. So that's a useful mechanism, and it helps in general to be a mechanism by which states can head off crisis, right? That if there's a disagreement over international law, rather than sort of throwing down and going to war, you have a legal process, a slow process that allows for states to sit down, dig through what the law says, look at the details of the situation, prepare their case, think through whether or not they're really in violation or not in violation, present their arguments, and by the time that process has played out, states might have realized, oh, we actually are in violation, and change their mind. But they also have time to maybe let tempers cool down, to maybe move an issue off the front page of the newspaper, to be able to have diplomats begin having conversations and maybe work out that disagreement without it even reaching the court. And so having this mechanism of international adjudication where states can sue each other and address disagreements about international law in a legal rather than sort of direct diplomatic confrontation kind of way is a useful mechanism in international relations. Okay, but there's also a coercive mechanism available, and built into the UN Charter is an enforcement mechanism that is linked to the UN Security Council. And so it's under Chapter 7, which is the section or the chapter of the UN Charter that creates the Security Council, and it gives the UN Security Council the power to impose sanctions or to use military force, to request resources from other states to be able to impose those sanctions or to be able to deliver military force, and it allows the UN General Assembly or the UN Security Council to make demands and resolutions and rules that are binding on all states. Now, every state that has signed on to the UN Charter has, in theory, promised to abide by the Chapter 7 Security Council rulings. That having been said, strong Chapter 7 action is pretty rare. Most Chapter 7 action looks more like this example I have here, but you could just even look through any of these resolutions, and it'll often be things like urges states to follow through on this, or encourages states that want to contribute resources to an anti-piracy effort to contribute resources, or welcomes the contributions of states that want to contribute to anti-piracy efforts, saying we demand Italy provide this and Japan provide this, is a little bit more than the UN Security Council has been willing to take in most situations. Oftentimes what it does is it legitimizes under international law the actions that states are already willing to take, and recognizes that and sort of builds it into gives it a legal framework. There's also regional organizations that sort of will work in tandem with the UN Security Council. Regional organizations are set up under Chapter 8. They don't have the power to impose binding resolutions on other states, but regional organizations will oftentimes work with the UN Security Council. And so particularly in resolving conflicts in Africa, the African Union has been very active in deploying peacekeeping operations and in terms of putting diplomatic and even economic pressure on different actors. And they've often done that in conjunction with the UN Security Council, where the Security Council provides the international legal framework for the enforcement mechanism, but the actual enforcement work is done by the regional organizations. So UN Security Council enforcement mechanisms oftentimes get a lot of criticism as slow or weak, and I would maybe suggest to you that that is very much by design, right? That we have an anarchic international system where no one's really in charge, no one's really in a position to tell other states what to do, and quite frankly, states like it that way. They're skeptical about giving anyone the power to order and direct and control the system. And so in addition to the Security Council generally sort of being tepid in terms of the demands that they make with Chapter 7 resolutions, there's also built into the UN Charter a prescribed process for enforcing international law. And so the process is start with not Chapter 7 powers of sanctioning and military force, but actually go a chapter ahead and talk about how states are supposed to interact in Chapter 6 with more bilateral relationships. Look at negotiation. Are your diplomats sitting down and talking? Look at mediation. Maybe you should use the International Court of Justice and do that adjudication thing. Maybe there are other techniques where states can work these issues out on their own. And it's only after you've exhausted those kind of actions that you convince yourself there's no possible way that we're going to be able to work this out without some sort of course of peace, then and only then can you move to Chapter 7. And yet when you move to Chapter 7, you're supposed to focus on sanctions, economic and diplomatic and communication disruptions, rather than military force. And it's only after you've demonstrated that economic sanctions and communication and diplomatic sanctions are not going to be able to work to resolve this issue, then and only then can you jump to military force and authorize military actions against a state. So there's, by design, a process that's very, very slow. Now you might note the little asterisk there. In practice, states have identified a way to fast track this process, right? And so in the case of military action in Libya, the UN Security Council or members of the UN Security Council looked at this and said, okay, we could go through this process of asking Libya to not slaughter its citizens in the Arab Spring uprising. We could ask for maybe observer missions to look at this and report. We could do all that Chapter 6 stuff. We could try with diplomatic sanctions or economic sanctions in Chapter 7, you know, that sort of non-coercive peace or non-military peace. But if we do that, it's going to allow time for the Gaddafi regime to essentially butcher its population in the streets, and that's just not acceptable. And so because of the timely nature of this issue, because if we go slow, it's going to have cataclysmic consequences, there's a sense of urgency, and we can jump to that final stage of Chapter 7 and actually launch a bombing campaign to prevent military operations against civilians in Libya. So in extreme circumstances, in time-sensitive circumstances, you can accelerate that process, but that's not the expectation that was sort of built into the UN Charter when this idea of coercive enforcement of international law and international peace and security was first laid out.